So let's dive in here and start out with just the basics. What does copyright protection extend to? So the standard definition, which is a lot less complicated than it sounds, is that copyright protection automatically applies to original works of authorship that are fixed in a tangible medium of expression. This can be broken down into two parts. First, original works of authorship. These are works that are independently created by human authors with a minimal degree of creativity. So what is that minimal degree? Well, it's very low. A work can satisfy this requirement as long as it possesses some creative spark. So as far as works of original authorship go, we will be discussing specific types that are typically eligible for copyright registration and protection. So that's the first half of the description. Second, we're looking at those works that are fixed in a tangible medium of expression. We're looking at something that's permanent or stable enough that can be perceived, or reproduced, or communicated for a period more than a transitory duration. So again, it's a lot less complicated than it sounds. An example that can really break this down for you is if you create a blog post or a podcast or an article, right there, those are typically going to be the original works of authorship. That is where your work can be covered by copyright the instant it's created in a tangible form, whether it's written on paper, an email, a video. So that is the fixed in a tangible medium of expression portion. So now that we have just the underlying definition of what is copyrightable, let's move on to what specific works of authorship are protected by copyright law. So works of authorship include the following categories: literary works, musical works, including any accompanying words, dramatic works, which include accompanying music, choreographic works, pictorial, graphic, and sculptural works, motion pictures, other audiovisual works, sound recordings, and architectural works. These are the general types of works that are protected by copyright law and are eligible for registration. Now, it's important to differentiate the typically eligible works of authorship from works that are not protected by copyright law. So in no case does copyright protection extend to ideas, procedures, methods, systems, processes. Here, we're looking at more of a patent-related group of intellectual property, which is a completely different subject. In addition, works that are not fixed in a tangible form or tangible medium of expression. For example, a choreographic work that has not actually been notated or recorded, or an improvised speech that hasn't been written down. Although those specific things may be qualified as original works of authorship, they're not fixed in that tangible medium of expression. It's not on paper. It's not on video. And then additional unprotected works, we have titles, names, phrases, slogans, symbols, or designs. Here, we're looking more at trademark law and the subject matter of what is potentially registrable as a trademark. In addition, mere variations of typographic ornamentation, lettering, coloring, again, that falls more in line with what could be registered for trademark as opposed to a copyright. And then finally, just a mere listing of ingredients or contents. Although that listing may be fixed in the requisite tangible form, it lacks that originality, or it doesn't fall within those categories of works of authorship. So now we've differentiated works that may be protected by copyright law and works that are not protected by copyright law. Specifically, they're usually falling into other fields of IP. Generally speaking, both trademarks and trade dress serve to identify goods and services as one's own, and they allow companies to protect their intellectual property or other aspects that make their business unique. So firstly, focusing on trademark law, this is the protection of logos, words, symbols, names that are associated with a product or service. So think of Apple. They have a registered trademark in their Apple logo. And then conversely, trade dress law protects the overall look and feel of a business or its products or the packaging of its products. So to the same example, Apple has trade dress protection of their physical store locations and their layouts. So we'll go into further detail regarding this total look and feel idea. Legally speaking, trade dress is an extension of trademark law or trademark protection. You may receive protection for trade dress under the Lanham Act, which is the body of law that protects intellectual property rights. And this can be the case regardless of whether your trade dress is actually registered. But this is as long as it meets certain requirements, which will be discussed in further detail as we move along here. So first, just briefly touching on trademarks. Trademarks, as previously stated, are recognizable identifiers like words, logos, phrases, or names that are associated with a business or an individual's goods and services. Two basic requirements need to be met for a mark to be eligible for trademark protection. First, the mark has to be used in commerce. This means that there has to be a bona fide or actual use or an intent to use the trademark in the ordinary course of trade. Second, there is an element of distinctiveness that the mark must have. And this distinctiveness addresses a trademark's capacity for identifying and distinguishing goods and services of one trademark owner from another. So switching gears over to trade dress. Trade dress comes from a court ruling from the 90s that referred to the way a product was dressed to go to market. Then the term's been expanded to include other elements like specific themes used in decoration or styling of a business location. Most recent definition of trade dress focuses on the total image instead of the way a product is quote unquote dressed up. So in other words, trade dress is the commercial look and feel of a product or a business that identifies and distinguishes the source of that business or product. And this can even include the packaging of products and as well as the atmosphere or decor within a place of business. So this look and feel is protected under trade dress because it serves to protect the ability of consumers to identify the source of goods or the business owner. A brief background of just NIL, name, image, likeness basics. Right of publicity law, which is referring to one's individual personality rights, prevents the unauthorized commercial use of an individual's name, image, likeness, or other recognizable character trait. So what do we mean by commercial use? Let's say that I want to go and make basketball jerseys, and on the front, I put Cleveland and the number 23, but I don't put a name on the back. In someone's mind, they may immediately associate that team name and that number with LeBron James, which I'll dive further into in the example below. But essentially, that's prohibited because NIL rights give an individual the exclusive right to license their use of their identity for commercial purposes. So without a license or permission, I can't make those jerseys, even if I'm not using an image or a name of that basketball player, because their likeness is being depicted. So just to touch on that example in more depth, not only does LeBron James hold the exclusive right to the commercial use of his name and image, he also controls the commercial use of his jersey numbers in association with basketball merchandise. So similar to the example as I was discussing, that number 23 in association with the Cleveland Cavaliers, it's an element of LeBron James' likeness. Likeness, in other words, it can be something that the public would immediately associate with that individual. So the number 23 in association with the Cleveland Cavaliers, an reasonable consumer would immediately associate the two as part of LeBron James likeness. So we're going to focus on these examples pertaining to athletes in particular, based on my background working on licensing agreements for athletes. So let's dive into some trademark basics just on a ground level and see how there's a slight difference in NIL rights, but also how they can be confusingly similar at times. So unlike publicity rights, trademark rights refer to words, symbols, or phrases associated with the sale of goods or provision of services. So one of the golden rules for a mark to be considered a registerable trademark, it must be sufficiently distinctive. What does that mean? It means that the mark must be distinguishable enough for a consumer to immediately identify the mark in connection with relevant goods or services. So for example, when you see an Apple logo, you immediately associate that with the Apple brand and the iPhones and the iPads and et cetera. It is distinctive enough where it's not exactly what the trademark looks like. It doesn't regard apples. It is distinctive in that it is reflecting a brand that consumers are widely knowledgeable of. So, for example, in the athletic basketball context, the shoe apparel brand Air Jordan, it's commonly associated with merchandise where a silhouette of Michael Jordan is depicted where he's dunking a basketball. The brand name Air Jordan, however, is a word mark that's separate and apart from the logo mark of the dunking silhouette. So you have the name Air Jordan, that's a registered trademark, but then you have the logo itself, which is a registered logo mark as opposed to the words alone. So these marks are distinctive because consumers immediately associate them with Michael Jordan and basketball shoes or apparel. Whether you see the name Air Jordan, we're thinking basketball, we're thinking Michael Jordan, we're thinking shoes. And when you see that dunking silhouette of Michael Jordan, you're immediately associating that with the same. So let's get into the overlap between trademarks and NIL rights. So although they're separate concepts, both NIL rights and trademark rights often intertwine, specifically in the fields of sports and entertainment. For example, this is a particular personality that I had the privilege of doing licensing work for in the past. For like MLB player Jackie Robinson, he's widely known for wearing the number 42 in his career with the Brooklyn Dodgers, who are now known as the LA Dodgers. Whether it was just his baseball career in general, breaking the race barrier in the MLB, or the film 42. So to differentiate the trademark aspect from the NIL aspect here, Jackie Robinson's estate holds trademark rights to the name Jackie Robinson and the number 42 in association with many categories of merchandise, for example, baseball jerseys. But separately, from an NIL standpoint, Jackie's name, his image, and the number 42 are independently protected under right of publicity law because they are intimately associated with his notoriety and his career with the LA Dodgers. So as you can see here, you can hold the trademark right to your name. And let's say you're an athlete and you have a jersey number trademarked as well. Those rights are separate and apart from the rights that consist of your name, image, likeness rights.